In this video, we are going to talk about what is will, probate, codicil, and letters of administration. All these topics are from Indian Succession Act 1925. But will is also a topic of Hindu and Muslim law both, but it is always governed by Indian Succession Act 1925. So Indian Succession Act 1925, which provides the essential conditions, how the will is to be made, what are the essential conditions of the will, and what is in fact the definition of will, probate. All these things are provided in Indian Succession Act 1925. So you should also remember that Hindu Succession Act and Indian Succession Act both are different. There should not be any confusion. Indian Succession Act applies to all communities except some exceptions provided in the act. So it is the Succession Act 1925 where we will be dealing in this video. So let's begin it. Now we will begin with will. So will is a legal declaration of the testator's intention regarding his property to be carried into effect after death. So whenever a legal document is prepared by a person who will be dying someday, and his intention is to with regard to his estate, to how he wished to dispose of the property, what he wished to do with his estate and the properties, is what that legal document declaration carries with. So it comes into effect only after the death of the person who is writing it. So will is a legal declaration of the testator's intention regarding his property to be carried into effect after death. So this is will, but obviously it is also defined there in Indian Succession Act what is will. So section 1 clause H of section 1 in Indian Succession Act provides will and defines it in following words: the legal declaration of the intention of testator with respect to his property which he desires to be carried into effect after his death. So these terms are specifically provided in the act. This is the definition of the will provided. So it is the same thing, that legal declaration of the intention of testator. Testator is a person who writes the will, and once he dies, the will can be executed according to the procedure provided in the act. So testator is the person who is writing the will when he is alive. So legal declaration of the intention of testator with respect to his property which he desires to be carried into effect after his death. So this is will. Now there are two types of will which is provided in the act. One is privileged will and second unprivileged will. Now we will discuss what is privileged will and then unprivileged will. A privileged will as per section 65. So section 65 of Indian Succession Act 1925 discuss about privileged will, and it says that it is a special. We will discuss 65 to understand what is privileged will and how it can be executed, what are the necessary conditions which makes a privileged will valid. So section 65 provides any soldier being employed in any expedition or engaged in actual warfare, or an airman so employed or engaged, or any mariner being at sea. So they are talking about, the provision talks about all three services of defense in India, and any of those officers can make a will which is called a privileged will. Now what are further conditions? So if he has completed the age of 18 years, dispose of his property by a will made in manner provided under 66, and such wills are called privileged will. So section 65 only talks about that soldiers, if they have completed 18 years of age, then in that case they can dispose of their property by a will, and the manner how that should be done is provided in 66. So now we come to 66. Section 66 provides mode of making and rules for executing privileged wills. So number 1 says that privileged wills may be in writing or may be in word of mouth. So privileged will can be in writing as well as can be made orally, and that this is not the condition in unprivileged will. We will discuss it later, because in unprivileged will only writing is the mode of preparing it. So here in privileged wills, both writing or orally it can be made. Second says the execution of privileged wills shall be governed by following rules. So subsection 2 provides the rules how what are the general rules applicable when will is there. So A says the will may be written wholly by the testator with his own hand. In such case, it need not be signed or attested. So when the testator himself writes the will with his own hand, then it does not require the signature or attestation, which is not the condition in unprivileged will. In unprivileged will, it requires attestation, signature, even if it is in writing. So this is the difference. Now we come to condition number B. It says it may be written wholly or in part by another person and signed by the testator. In such case, it does not need attestation. So B says if it is not written by the testator himself, but he must sign it, and even in this case, the attestation still is not required. So even in B, it is different again from unprivileged will. Now C says if the instrument purporting to be a will is written wholly or in part by another person and not signed by the testator, it shall be deemed to be his will if it is shown that it was written by the testator's direction or that he recognized it as his will. So even if he has not written it and not signed as testator, but still it will be deemed to be his will if it has been shown that it was written by the testator's direction or that he recognized it as his will. So this is a matter of evidence that when a will is prepared by somebody else in privileged will cases, then the evidence must be shown that it was written on his direction, or that he even it is a doubtful will that it is not proved that direction was there or not. It should be proved that he recognized that person when he was alive, he recognized that will as his own will. So this is condition number C. Now D says if it appears on the face of the instrument that the execution of it in the manner intended by the testator was not completed, the instrument shall not by reason of that circumstance be invalid, provided that his non-execution of it can be reasonably ascribed to some cause other than abandonment of the testamentary intentions expressed in the instrument. So even if the formality of the will is not completed, and when it is to be executed, its formalities intended by the testator is not completed, even in that case, it is not invalid by that reason only. Only case where it will not be a valid will when the intention of the testator that he does not further recognize the will, he is abandoning it. So in that case, if the formalities are not shown to have been completed in the manner it is provided by him, then in that case it is invalid. Except that reason, it is a valid will. It cannot be invalid merely because the formalities were not, the manner of the execution was not as per the testator's intentions. So D is here. Now E says if the soldier, airman or mariner has written instructions for the preparation of his will but has died before it could be prepared and executed, such instructions shall be considered to constitute his will. So it is written that even in his instruction a will is to be prepared, but it could not be before his death. In that case, these instructions shall be considered as a valid will. So this is E also comes under the privileged will conditions. Now F says if the soldier, airman or mariner has in the presence of two witnesses given verbal instructions for the preparation of his will, and they have been reduced into writing in his lifetime, but he has died before the instrument could be prepared and executed, such instructions shall be considered to constitute his will, although they may not have been reduced into writing in the presence nor read over to him. So it provides then whenever there is a verbal instruction by any of these categories officer, and it has been these instructions are reduced to writing, and but the condition in F provides also that he died before the preparation of instrument on those instructions. Even in that case, they may not have been written and not read over to him when he was alive. Even then it is a valid will. Now condition number G says the soldier, airman or mariner who make a will by word of mouth by declaring his intentions before two witnesses present at the same time. So a will by oral will by these officers in presence of two witnesses present at the same time would be a valid will. So this will can also be made by this method also. H says a will made by a word of mouth shall be null at the expiration of 1 month after the testator being still alive has ceased to be entitled to make a privileged will. So if a will made by word of mouth, which means oral will, is not valid after the expiration of 1 month, and the testator alive but he does not convert the will into writing, in that case the provision suggests that oral will by the person who is any officer of any of these services, and on the expiration of 1 month and he is still alive, that will cease to be a valid will, because as per the provision, if it is not converted in the provision implies that if it is not converted into a writing, then oral will after the expiration of 1 month, if he is surviving, if he dies before 1 month, in that case it would be a valid will, it will not be null. But if it is 1 month expired and it is not converted, by implication not converted into a writing, then it shall be an invalid will. So these were the provisions, the conditions of unprivileged wills, which can be made only by the officers of those services provided in the provision. Otherwise, the common citizens prepare unprivileged will, which are the general wills, how the wills generally are prepared. So this is provided. We are going to discuss it. What is the same? Unprivileged will. An unprivileged will is a standard testamentary document that must be in writing and comply with the requirements of Section 63 of Indian Succession Act. So wherever a concept of will comes into questions, you have to write an answer. Section 63 of Indian Succession Act is very important because it talks about the formalities, what will is, how it is to be made, prepared, and what are the necessary conditions. Only then it will be a valid will. We have already discussed the definition of will there in interpretation clause there in the act, but there are obviously two types of will, privilege and unprivileged. Privileged will is for some category of officers provided under the act. Only those officers can make that will, and only for them it is a valid will, and it can be oral and writing, and there are, as we discussed, the conditions according to which how it can be regulated. Now unprivileged will is for common people, the citizens, which are not those officers, and it is a testamentary document prepared by a person when he is alive with regard to his estate, how that is to be administered after his death, what should be done with those properties of that person after his death, is what that document in writing and in accordance with Section 63 talks about. So now what Section 63 says: execution of unprivileged wills. So it says every testator not being the soldier employed in the expedition or engaged in actual warfare, airman employed or engaged, or mariner at sea. So except those people, all this provision is applicable to every person. So every testator. So rules are: A says the testator shall sign or shall affix his mark to the will, or it shall be signed by some other person in presence and by his direction. So either he can himself sign or affix his mark, or on his direction some other person, his presence, can sign it on his behalf. Then B says the signature or mark of the testator or the signature of the person signing for him shall be so placed that it shall appear that it was intended thereby to give effect to the writing as a will. So the signature and mark should be visible. This is the condition B. Now condition C says the will shall be attested by two witnesses, two or more witnesses. Minimum two witnesses must be there, and each of whom has seen the testator sign or affix his mark to the will, or has been some other person sign the will on his behalf and in presence and by the direction of the testator, or has received from the testator a personal acknowledgement, either it can be acknowledgement of his signature or mark, or of the signature of some other person, and each of the witnesses shall sign the will the presence of the testator, but it shall not be necessary that more than one witness be present at the same time, and no particular form of attestation shall be required. So the will should be attested by two witnesses. This is the condition C, and both these witnesses signing in must sign in presence of the testator, and if both the witnesses need not be there signing at the same time, the time can be for both different, and they can sign at different times, but must be in presence of the testator. This is the mandatory condition, but no particular form of testation shall be necessary. It can be in any form. So this is C. Now we will discuss section 59 of the Succession Act. It says every person of it talks about what persons are capable of making wills. So it says every person of sound mind, not being a minor, may dispose of his property by will, and explanation are there 1, 2, 3, 4. So the condition first of all is that sound person and not should be a minor can dispose of his property by making a will. But what are the explanation? One says a married woman may dispose of by will of any property which she could alienate by her own act during her life. So for what she is legally entitled to dispose of any property, a married woman can also dispose of by will. The explanation 2 says persons who are deaf, dumb or blind are not hereby incapacitated for making a will if they are able to know what they are doing. So it is clear that the blind, deaf and dumb people can also dispose of property by making a will, but it should be the scenario that they are able to know what they are doing. One must know what he is doing is the condition, explanation 2. Now 3 says a person who is ordinarily insane may make a will during intervals in which he is sound mind. So whenever an insane person is sound, if he is in intervals as sane and insane, whenever he is of sound mind, at that time in that interval he can prepare a will, and that is a valid will. Explanation 4 says no person can make a will while he is in such state of mind, whether arising from the intoxication or from illness or from any other cause, that he does not know what he is doing. So in those cases the will would not be valid, that he was intoxicated, ill, or there can be any other cause and he doesn't know what he is doing. In such state of mind, any will made, even if it is prepared, it is not a valid will as per explanation 4. So we will talk about some illustrations, discuss some illustrations provided under the act. And so illustration is A can perceive what is going on in an immediate neighborhood and can answer familiar questions, but has not a competent understanding as to nature of his property or the persons who are of kindred to him, or in whose favor it would be proper that he should make his will, cannot make a valid will. So whenever a person, even if he is able to answer questions, he understand his surroundings, the familiar questions, but he does not know about understand the nature of his property, who are his family. Kindred means here his kins and his family and his relatives. He does not know, understands about them. In that case, he cannot make a valid will. Now, illustration second. A executes an instrument purporting to be his will, but he does not understand the nature of the instrument, not the effect of its provisions. This instrument is not valid. Generally, if you see the rules prevalent in the law here in India, is that a person cannot excuse the law. This is how we understand the general provisions, general principles of law, that one cannot later say that he did not know the effect of the law. But here, if the provision specifically provides about the questions regarding his competence, whether the person is of sound mind or not, in such cases, as the person is dealing with his property, it is a sensitive matter where he is conveying some property, making a legal document which will have a legal sanctity, that it will convey some property to another, transfer a property to another person. In such cases, it is important that a will it is always the law. Even Honorable Supreme Court says that in cases of will, there should not be even a single suspicion existing at the time of scrutinizing a will. So this is what this provision is all about, that even if the person is not understanding the effects of the instrument he is preparing, even in that case the will is not valid as per illustration second. Now condition, the illustration third says, A being very feeble and debilitated, but capable of exercising a judgment as to the proper mode of disposing of his property, makes a will, and this is a valid will. So feeble and debilitated means that he is a person who is weak and not in a good state of health. He is sick, but capable of exercising a judgment as to the proper mode of disposing of his property. In that case, it is a valid will. So these are the illustrations you can understand, by which you can understand how in cases of a person who are not in good state of mind, when the will would be valid and not. So after reading the provisions properly, we can figure it out what are the essential conditions of unprivileged will. There we discussed the provisions regarding privileged will, but generally it is the unprivileged will which is generally we deal with. And what are the essential conditions? So condition number 1 is that it must be always in writing, signed by the testator and attested by at least 2 witnesses, and at least 1 witness must be examined in court. And Indian Evidence Act, we know that the will need not be a registered document. Even in the Registration Act, we know will is not a mandatorily registrable document, and even if it is registered, 1 attesting witness is required to be examined. This is the provision of Indian Evidence Act, and as per Registration Act, the will is not a mandatory registrable document, and a person's choice is as such that he wish to get it registered, it can be registered, but it is not mandatory to get it registered. But here the attestation is a mandatory condition, essential condition, that it should be attested by 2 witnesses, and at least 1 witness must be examined to prove the making of the will before the courts of law. Second condition would be that the mode of proving a will involves demonstrating its proper execution, including examining witnesses as per 63, as this is what we have discussed in essential condition number 1. Then also capacity and free will. Free will is important. It should not be undue influence or coercion, fraud, or the person making the will must be of sound mind. This is what we have just discussed, that these are the essential conditions. Only then a will is a valid will, otherwise it is not a valid will. And with this regard, there is a provision, section 61, which says that will obtained by fraud, coercion, or importunity is not a valid will, and it is a void will. A will or any part of a will, the making of which has been caused by fraud or coercion or by such importunity as takes away the free agency of the testator is void. So as we have already discussed, that the without the free will of the maker of the testator of the will, it is not a valid will. If fraud, coercion, any compulsion is there on part of the whose benefit it may be prepared, it is whomsoever influences the testator in such conditions, even if the will is prepared, it cannot be a valid will, so it will be void. Now there are other provisions also, that how revocation of will can be revoked. Yes, it can be revoked. What the effect of a marriage of a person, and if he has already a will prepared, whether it in some circumstances that will becomes void, it is no more a valid will. So these are some special circumstances where these provisions comes into play when there are such circumstances. So these are some special provisions. We will later discuss those provisions when we are solely talking about will. Here I have brought this video on 4 topics. So this is the general understanding, the essential provisions which I have discussed yet about will. Now we'll go forward with probate. So probate is defined under 2F of Indian Succession Act, and 2F provides probate means the copy of will certified under the seal of a court of competent jurisdiction with a grant of administration to the estate of testator. So here probate means a copy of will. So there should be a will which should be a valid will, and it is certified by the court of competent jurisdiction. The seal of the court means that court is giving it a legal recognition, and court examines the validity of the will. Here the party, the executor who comes with the copy of a will, and it gives it legal recognition by putting a seal on the will. So this is how it becomes a probate, and that copy of the will becomes a probate. This is to be understood, that the will under the seal of the court, certified by the court, that it is a valid will, it is a right will, then in those cases it is a probate. and that can be with it is granted for the administration of the estate of the testator, and it must be a competent court. Competent court is a district judge for the making probate, and in those cases it becomes a probate, and probate is ultimately a will. Also, will is the same thing as a will, but recognized as valid in the eyes of law, approved will, you can say. Now we will talk about to whom probate can be granted. So section 222 of Indian Succession Act provides that probate only to appointed executor. So the probate shall be granted only to executor appointed by the will. So will must talk about the person who shall be the executor, and only to that person the will shall be assigned, granted, and the appointment may be express or by necessary implication. It need not be directly mentioned in the will that this named person should be the person. It can be by the implication that it implies to some individual or number of people to be executors. In that case, it will be the person who shall be the executor, even by either expressly provided or by implication. So we see the illustrations also. Now number 1 says, A wills that C be his executor. If B will not, B is appointed executor by implication. So you understand this provision, this illustration, that A wills that C be his executor if B will not. So it is saying that first B should be the first option, that the B shall be the executor, and if B denies or B is not in existence, B is no more there, in those cases only C shall be the executor. So by implication, B is the executor, that he is saying that that C be his executor if B will not. So the language itself is suggesting that first option is B to be the executor. Now who is the executor is provided under definition 2(1)(c), and it says a person to whom the execution of the last will of the deceased person is by testator's appointment confided. So to whom that last will of the deceased person is confided to is the person who is the executor, and he only deals with the estate of the person deceased, the testator, and this is what executor is under the act. Now there are further illustrations. Illustration 2 says A gives a legacy to B and several legacies to other persons. Among the rest to his daughter-in-law C, and adds, but should the within named C be not living, I do constitute and appoint B my whole and sole executor. C is appointed executrix by implication, as it provides the language provided is that, but should the name C be not living, I do constitute and appoint B my whole and sole executrix. So if C is not living, but if C is living, then should be the executor, is what the implication is, can be drawn from the language of the will. So this is how implication works. Now another example on implication. A appoints several persons executors of will, and codicils. What is codicils? We are going to discuss later. And his nephew residuary legatee, and in another codicil there are words, I appoint my nephew my residuary legatee to discharge all lawful demands against my will, and codicils signed of different dates. The nephew is appointed an executor by implication. So the language suggests that my nephew residuary legatee to discharge all lawful duties against my will, and codicils signed of different dates. So it says that all the wills and codicils for which my residuary legatee to be the executor, and this is also by implication that it says that all lawful demands against my will and codicils signed off different dates. So he prepared another codicil, and after all these earlier codicils and wills, this is the updated one, in which he says that the nephew is to be executed by implication. So the nephew is the executor, and this is illustration C. So I hope you understood what is implication. The executor by implication is to be drawn from the language of the will. Now, whether several executors can be there, so yes, several executors it can be granted to, probate can be granted to several executors simultaneously or at different times. So, it is section 224 under which it is provided. We can see the illustration. A is an executor of B's will by express appointment, and C an executor of it by implication. Probate may be granted to A and C at the same time, or to A first and then C, or to C first and then A. So this is how more than one person can be executors at the same times also, simultaneously also at different times. In case of death of the executor of the will, so 226 provides for such a problem, accrual of representation to surviving executors. So when the probate has been granted to several executors and one of them dies, the entire representation of the testatus accrues to the surviving executor or executors. So this is the situation where one of the executors dies. Now it is further provided to whom probate cannot be granted. So section 223 provides for the same, and it says the persons to whom it cannot be granted. So a minor, unsound mind person, any association of individuals, unless it is a company which satisfies the conditions prescribed by the rules to be made by the notification official gazette by the state government in this behalf. So generally, association of individuals except the company shall not be the persons to whom the probate cannot be granted. So minor, unsound person or association of individuals except the company who satisfy the conditions prescribed by the state government. So in those cases, the probate cannot be granted. Now, what is the effect of a probate? So, probate of a will, when granted, establishes the will from the death of the testator and renders valid all intermediate acts of the executor as such. So, the will becomes a valid will. It is proved, and all acts of the executors are considered valid as if the as the executor is considered as the representative of the testator. So here also you see the under the Evidence Act. Evidence Act provides there that now the Bharatiya Sakshya Adhiniyam, that the decision of a probate court is a conclusive proof of what it decides. So whatever is the decision of a probate court, it is a conclusive proof of what is stated in the decision. So now 248 is very important provision which talks about what is the use of the probate. Probate is limited to purpose specified in the will. If the executor appointed for any limited purpose specified in the will, the probate shall be limited to that purpose only. And if he should appoint any attorney or agent to take administration on his behalf, the letters of administration with the will annexed shall be limited accordingly. So this is how it provides that for the purpose for which the executor is to be appointed as per the will, is the effect is limited to that purpose only of the probate. So now we see what are the objects of probate, what purpose it serves. So the probate is a legal process that involves the validation of will and appointment of executor named in the will to manage the deceased property, estate or property, and primary object of proceeding is to establish the genuineness and due execution of the will, ensuring the deceased wishes are honored. So the object of the will is to establish the genuineness and the execution of the will, due execution of the will, and the deceased wishes are honored is the object of taking probate, grant of the probate. Then further, the probate court is responsible for preserving the original will in its custody, which is crucial for preventing disputes regarding the will's authenticity in the future. And then for very important, that the probate court does not decide the questions of title or disputes with regard to right over the properties, but on the will's validity and executor's appointment. So it does not decide the substantive rights of the people who may have any right over the property after the death of deceased, the testator. It just decides about the will, its validity, and who would be the executor. Is the only things which are dealt with by the probate court. Now we come to what is codicil. So it is also defined under 1B, 21B of the Succession Act, and it says an instrument made in relation to a will. So instrument made in relation to a will, that means a will should already be available when at the time of codicil, and explaining altering or adding to its dispositions and shall be deemed to be part of the will. So, it says that a codicil is an instrument made in relation to a will. It is talking about, the codicil is always talking about some will already in existence, and it is explaining something, altering something, or otherwise adding something in its disposition, and shall be deemed to be part of the will. So, codicil shall always be deemed to be part of the will. It's kind of an amendment, it may be some alteration, maybe some explanation provided with in an instrument with regard to some will already in existence, and that is what codicil is all about. Codicil is always a part of the will. It is considered a part of the document, considered a part of a will, and all the formalities of will are required for a valid codicil. Otherwise, codicil is not valid. All the formalities of the will are to be complied with for a valid codicil. Here, codicil is not a standalone document. It is an extension of will. It relates to and must adhere to the same legal requirements for execution and attestation as a will itself, right? So, will is not a codicil cannot be a separate document in absence, the non-existence of a will. If there is no will, there cannot be any codicil. For codicil, it is, you can say, an amendment, a change, an alteration document with regard to a will. So, there must be a will, and then only codicil can be made with regard to that will, and codicil should also comply with the requirements, the legal requirements and attestation, everything as a will requires. So, this is clear. Now, section 225 provides separate probate of codicil discovered after grant of probate. For example, any probate has already been granted on a will, and then it has been discovered that there is a codicil also in existence, which later comes into information of the court and of the party, anybody, and there is an application moved, and in that case a separate probate of that codicil may be granted to the executor if it in no way repeals the appointment of executors made by the will. So, if codicil has been found out, in that case a separate probate can be granted, but there should be this there is a condition that if it no way repeals the appointment of the executors made by the will. So, executors should be the same, only then the separate probate on that codicil can be granted. But in cases different executors are appointed by the codicil, the probate of the will shall be revoked and a new probate granted of the will and the codicil together, right. So, here if the executors are changed by the will provided in the will, different from the provided in the codicil, different from the will, and in those cases the probate of the will shall also be revoked. The earlier executors appointed shall be revoked and new probate shall be granted together with the codicil. So, this is subsection 2. Now, we come to letters of administration, and it is not defined in Indian Succession Act, nowhere defined, but we can understand what is the meaning of letters, what is letters of administration. It is a legal document granted by a court that authorizes an individual, the administrator, to manage and distribute the estate of deceased person who has died intestate. Now, very interesting, intestate means he did not prepare a will before his death. So, he did not, any person who died and whose estate are to be administered, he did not die with any will, he did not prepare any will before his death. He is by the court to administer the property estate of the person who died intestate is called, that document is called letters of administration. And there is a further situation, or when there is no executor available to act, also in those cases where the executor is not there, even if a will is there but the executor is not appointed, in those cases also letters of administration can be granted, issued by the court. So, it is very important when the person dies intestate, or where even he is dying with a will, in those cases where the executor is not there, on application letters of administration can be granted to the people who are applying for the same, and those people are called legal representative, he serves as legal representative for the deceased estate. So, I hope this is very clear that when letters, what is letters of administration, it is just the authority from the court document on the basis of which the estate of the deceased person can be administered, his debts, his assets, how those are to be disposed of is the authority given by the court in a way of manner of document given to a person who is the administrator, and he will be dealing with the property, which is called the administration, and the document is called the letter. So here this is what letters of administration. Administrator is defined under the act, and it says a person who appointed by a competent authority to administer the estate of the deceased person when there is no executor. So even in cases of will where the executor is not appointed, an administrator can be appointed to administer the estate of the person who died. And in those cases where the will is not there, definitely in those cases also the administrator can be appointed, and the authority issued in a as a document, then it is called a letters of administration.